Maybe it wasn't true
Yeah.
because. All right, so David, we're just going to start with your first and last name and spelling, please.
David A. Torres, Torres.
And tell me how you're feeling right now.
Well, first of all, I do have to note that this jury, they did take their time. They were very attentive. And for the most part, that's all that any attorney can ask for in our jury system because it's such an important job. And I did have an opportunity to speak to the jury afterwards. And I did thank them for their attentiveness to this case. But I'm elated that she wasn't convicted of any second-degree homicide. But at the same time, it appears that we do have to perhaps retry this case.
Yeah, how is she feeling?
Well, you know, she's obviously upset. We were hoping that we would get an acquittal on this case. And this was quite an intense 3-week trial. And we put on as much evidence as we possibly could to set forth our position on the case. But unfortunately, the jury didn't see it that way.
What can you tell us about what you think went on in the jury room? You know, why they couldn't come to an agreement?
You know, the jury is an interesting sanctity, if I can use that term. Obviously, they discuss the facts. There are certain things that jurors probably will see that the attorneys won't see. And in the course of the discussion that we've had with them afterwards, they picked up on little cues here and there. And a lot of times, some things may have to do with the quality of the evidence. It may have to do, perhaps, whether or not some believe that the defendant was credible. And in this particular case, I'm not going to say that they didn't find Ms. Bowers not credible. However, I think that there may have been inconsistencies throughout the case. But I do want to point out, it's not that she was not credible. This was a rather extended amount of time that she was, in fact, on the stand when she testified. And you know, if there was an inconsistency, based upon my recollection, it wasn't something that was ear-shattering, so to speak. It was something, perhaps, that, in my opinion, that may have been small. So again, what we have to do is we have to go back to the drawing board and rethink whether or not we're going to consider the possibility of engaging in negotiations to resolve this case, or whether or not we're going to retry it.
From the little I talked to the jurors, it sounded a bit like they did find her genuine, in the sense that they really thought that there could be a chance that she really did suffer all this abuse, but that the evidence made them feel like, oh, I don't know, the way that the actual shooting happened put them a little
uneasy.
Yeah.
And I think the word would be uneasy. And I think that what has to be understood is that, yes, she did have a relationship with Raymond. Yes, in this particular case, there was a disagreement and there was perhaps an argument. And yes, Ray did have a history of being abusive towards her. But I think that in this particular case, the jury may have believed that using the firearm was a tad bit excessive. Now, that was the essence of our defense in this case, using Dr. Masako, because a person in her situation, being a battered spouse, has a higher sense of fear, has a higher sense that of imminent peril or danger, that she may be on the receiving end of great bodily injury or death. But as I told the jury, it doesn't matter if the word death bothers you. I can understand that, but consider the fact that you have great bodily injury and you know that you've been in a situation before where you've been attacked or beaten or spat on or kicked. They needed to understand that. But again, I guess when you take a look at the totality of the picture, they may have believed that the firearm was too excessive. On the contrary, I believe that it was necessary under the circumstances.
Okay, and so, correct me if I'm wrong, we received a tip from inside the DA's office that there was some jury obstruction that led to mistrial. So if that's not part of it and it was just the jury deadlocked, then if that was consistent, then maybe you can share that right now?
Well, if you received some tip that there was jury obstruction, I have not heard of that. And if there was an issue of jury obstruction, we as the attorneys in the case, as well as the court, would have heard about that directly firsthand. And there are ways for courts to handle a situation like that. So if that was something that you heard from their office, it's nothing more than an unsubstantiated rumor, because everything was up to par in this particular case, especially with the jury.
And my last question, I guess, would just be for people who have no idea what that means, jury obstruction, in a Wikipedia intro version summary, how could you say what that is?
Well, I quite frankly don't even, with all due respect, I don't know what you're talking about. I mean, jury obstruction can mean it's open. I mean, I think what you're trying to say is that if there was somebody in the jury that was obstructing or maybe a holdout, that's a different situation. That is not what the situation was in this particular case. Even if you have, quite often, you're going to have a jury that's going to be 11-1, 10-2, 9-3. And initially this was 9-3, and ultimately a couple of jurors ended up deciding towards the second degree, which ended up being at 11-1. But one of the things that is important in this particular system is that a juror has the right to hold out and not render a decision with the other ones. That's the beauty of the system. If somebody told you that was obstruction, they are absolutely incorrect. In fact, that is something that I speak to jurors about in voir dire, that a juror has they are a sovereign, consider themselves as an individual, and they have to think as an individual. Ultimately, they deliberate as a group. But if they firmly believe against the entire group, they as a right have that right to decide on what they want to decide on. So that is not obstruction.
Have you ever tried a case twice?
Personally, I have tried a case twice, once. In my career, I am not a fan of retrying cases, and so again, I have to make that determination as to whether or not that's going to happen here.
I know you probably don't want to speculate on this, but maybe if you would consider it. I mean, do you think that do you think the DA's office is going to want to retry it based on the juror's decision? Here's the deal, and this is something that we have to really consider. The district attorney's office can take a look at the breakdown of the jury in this particular case, and they will probably use that as leverage against me. On the other hand, however, I think I strongly believe in my client. I'm strongly passionate about this case, and I think that if we put it up before a jury again, it may either, one, become a not guilty, or on the other hand, the jury may hang up another time. Who knows? But the fact that the jury ended up with this particular breakdown, that doesn't let me down at all. What I know is that, hey, I get another day in court, and I have another opportunity to fight for my client, to show why my client should be acquitted of these charges, and I will continue to do that as long as my client allows me to. Any other questions? Anything else you want to say about the case?
No, that's about it. But thank you very much for spending your time here.